AI using topic modeling. So, Constanta, you have 12 minutes for your presentation, plus 3 minutes for questions. And if people have questions, please write them in the chat of the Zoom meeting. And let's start.
Thank you. Hi, everyone. I'm Constanta Rosca, and in this presentation, I'll talk about our joint work with Bogdan, Covrig, Catalina, Goanta, Gijs, Dijck, and Gerasimos, Spanakis, titled Return of the AI, and an analysis of legal research on artificial intelligence using topic modeling. Let's provide you with some context first. While decades ago, interest in AI was generally limited to specific disciplines like computer science and philosophy, the most recent AI hype was embraced by considerably more disciplines, including law. The spike in the number of publications raises a number of questions. With over 2,500 legal publications already by the year 2015 referring to artificial intelligence, it may no longer be realistic to assume that researchers can keep up with literature in this field or the number of publications in general. The research spike also suggests that more and more authors have started writing about AI and law topics, including authors who have previously not published on such topics. This, in combination with the inability to keep up with legal research on AI due to its exponential growth, creates the risk that authors replicate previous work without being aware of similar publications. Against this background, we set out to determine what legal research on AI constitutes of and how it has evolved while addressing the issue of information retrieval and the risk of research duplication. In doing so, we address 3 research questions. First, we investigate which topics within the field of legal research on AI can be distinguished. Second, we look into how legal research on AI has evolved topic-wise. Third, we ask whether similar papers can be detected. As a result of a data sharing agreement with Hein Online, which is one of the leading international databases on legal materials in the world, we obtained a dataset of almost 4,000 documents reflecting the journal articles resulting from the query artificial intelligence. For the purpose of our study, even one reference to the keywords was deemed sufficient to include an article in the corpus. And so, with a unique dataset made available to us, we embarked on answering our first research question: which topics within the field of legal research on AI can be distinguished? Corpus preprocessing involves filtering for articles written only in the English language and afterwards removing common English subwords and some very common corpus-specific words. We also consider the presence of either unigrams or bigrams to be able to capture some concepts like dispute resolution. Subsequently, LDA was used to identify topics in the corpus. For identifying the number of topics, we used perplexity and coherence measures on a held-out set. We started from 5 topics and increased the number of topics till 100 with a step of 5. A plateau in both perplexity and coherence could be observed around 35 or 40 topics, which suggests a computationally optimal number of topics. Based on this, 2 of us inspected the results of topic models of 30, 35, 40, and 45 topics in order to determine which number of topics were substantively the most meaningful. For this, the researchers were provided with the 20 terms of the highest weights for each topic. Based on this evaluation, we selected a topic model consisting of 35 topics. The topic validation consisted of 2 steps. First, 3 of us inspected the 20 terms for each topic in order to label the topic. Second, paper titles were inspected to determine whether they supported the assigned label. If not, the label would, if possible, be adjusted. For this purpose, the researchers were presented with a list of paper titles for each topic. The validation process indicated that the vast majority of the LDA-produced topics were substantively meaningful. 3 miscellaneous topics were also identified. Both the inspection of the 20 words and the titles did not result in a substantively meaningful label or description for these topics. Overall, the model performed considerably well in identifying latent topics in our corpus. The results show a wide range of topics, including topics like autonomous vehicles, algorithmic decision-making, quantitative methods, privacy, and competition in markets. Within each topic, diversity could still be observed. Table 1 shows the 35 topics produced by the LDA model. It includes the topic IDs, the 10 terms that have the highest weights in relation to the topic, and the labels that we assign to the topics. An important issue in our study concerned the initial selection of journal articles. The articles were selected based on the search string artificial intelligence. The number of occurrences of this string presumably is, however, not an entirely accurate proxy for measuring whether the paper actually is about artificial intelligence. It might be that papers in topics like public policy or competition markets mention the term artificial intelligence, but do not primarily focus on artificial intelligence or even on technology or digital matters. An additional selection was therefore required. Consequently, 3 of us independently went through the topic list and the related words in order to determine whether the labels and words are likely to be related to AI, digital, and/or technology. Ultimately, a total number of 18 topics was selected. These topics are shown in bold in Table 1, and they were used in answering our second research question, how has legal scholarship on AI evolved? To answer this question, we needed to determine which of the 18 topics that were selected have gained or lost attention over time. The first step towards that was to extract the dominant topics of each paper using the document topic vectors. To assess topic relevance, two of us manually reviewed the 5 topics with the highest relative weights for a sample of documents. They agreed that for most documents, their relevance dropped significantly after the third topic, and the latter topics provide little to no substantive contribution to the paper. Based on the results of this inspection, the top 3 topics of each paper were denoted as dominant. We define the frequency of a topic as the number of times that a topic is dominant in all articles. Linking the topic frequencies to the year of publication, the count of papers addressing each topic every year was computed. Figure 3 depicts how the 18 selected topics evolved over time. The topic river shows fundamental changes in legal research on AI from 2 perspectives. On the one hand, the total number of papers referring to AI sees a sharp increase since 2016, and on the other hand, the diversity of the topics also increases over time. This can be mostly contextualized by the occurrence of new technologies, such as the internet, leading to the emergence of a new topic on internet governance in the early 90s, but also by the granular development of existing technologies. In terms of the evolution of the topics, a lot of these developments can be contextualized further by looking at the history of AI research in computer science. In a previous publication, some of us identified 5 major periods in AI history: the first AI boom, the first AI winter, the second AI boom, the second AI winter, and the third AI boom. Over part of the third AI boom, we looked at the deep learning era, which spans the years 2012 to 2018 in our corpus, separately, given that it highlights a unique breakthrough in unsupervised machine learning methods, which we think merits independent consideration. As a measure of relative topic popularity during a certain period, the ratio of papers concerned with each topic to the total number of papers written in a certain period was computed. Figure 5 shows how the topics have evolved in relation to other topics across the 6 major periods in AI history. The first AI boom was a period of exploration and reasoning, which saw the development of theoretical models. In this period, there were relatively few papers on AI and law. Scholarship focused on topics such as knowledge-based systems or algorithmic decision-making and quantitative methods, with the topics trends in legal technology and information retrieval establishing their prominence during this time, forming the subject matter of 45 and 21% of the total number of papers respectively, as legal scholars start exploring what technology can do for law. However, the popularity of these 2 topics was short-lived, as interest in them mostly decreases as of the first AI winter, a period characterized by general loss of interest in AI research, but at the same time a moment when the first critical analysis on the impact of AI on society start to appear. During the first AI winter, the topics copyright, privacy, and military technology come to the scene. The second AI boom brought with it a focus on knowledge-based systems, but also the rise of personal computing and precursor telecommunication networks to the internet, which led to more individuals enjoying new technologies, but also being at risk from their negative repercussions. This might potentially explain why new topics such as surveillance, internet governance, and software licensing emerged during this period. More recently, during the third AI boom, and more specifically during the deep learning era, the promising growth of deep learning led to new concerns, such as algorithms that cannot be explained being deployed by public or private actors to the detriment of fundamental rights, such as privacy. This development can be said to go hand in hand with topics identified during this period to have a notable rise in popularity, such as privacy, military technology, regulation of innovation, and autonomous vehicles. Lastly, we looked into whether topic-wise similar papers can be detected. For this purpose, we computed a cosine similarity between all possible pairs of documents in our corpus using the document topic vectors, and then proceeded to explore the substantive meaning of the similarity scores. In this process, the results produced by the cosine similarity algorithm were compared to substantive similarity as defined by one of the legal experts on our team. The goal of the inspection was to explore the extent to which the papers were similar and whether differences in similarity scores produced by the cosine similarity measure are substantively meaningful differences. For this, 5 papers on different topics were selected, the seed papers. Each of these 5 seed papers were compared with 5 papers with different similarity scores, the comparison papers. The comparison took place on 4 levels: the paper title, the research question level, the focus or subtopic level, and the citation level. Without knowing the similarity range that the comparison paper falls under, the legal expert ranked the similarity for each pair of papers for each topic separately. A Spearman's rank correlation test showed a high correlation between the orders produced by the machine and by the human expert. The inspection of the paper suggests that papers with similarity scores of 0.85 or lower may share substantive similarity, but in a limited way at best. However, articles with high similarity scores, particularly those with a score of 0.90 or higher, are also substantively similar, at least in the case of the inspected papers. And on this slide, you can see an example of two papers with a similarity score of almost 0.99. From reading the titles alone, it already becomes clear that both papers discuss autonomous weapons from the perspective of international humanitarian law. Of course, our study does not come without limitations. First of all, we do not claim that our corpus is representative of all legal scholarship published on AI. That being said, Hein Online does contain and represent a large and important part of legal publications. Another limitation regarding the corpus concerns the initial selection. We selected journal articles that included the keywords artificial intelligence. Had we selected different keywords, the corpus might have looked differently. However, legal scholars don't always agree on and standardize the terminology used in scholarship relating to technology. Some scholars might prefer to refer to artificial intelligence, others to algorithms or to machine learning specifically. As matters currently stand, it's difficult to label certain terms as being more descriptive of content relating to AI than others. Lastly, the analysis that explored the increase or decrease of publications over time used the three most dominant topics to determine whether topics have become more or less relevant. The results might also be different if less relevant topics are taken into consideration. So to sum up, the results of our study provide insight into how legal research within the theme of AI has evolved over time. Beyond that, our results provide support for the development of tools using methods like LDA to assist in structuring large document collections and in finding relevant papers, with the purpose of providing solutions for reading and analyzing publications in bulk in ways that humans cannot. And in our quest to develop solutions for dealing with vast amounts of literature, we're currently exploring the possibility of applying and comparing different topic modeling algorithms such as dynamic LDA and incorporating the latest NLP representation models, namely word embeddings using either word2vec or BERT. Moreover, we want to apply our methodology to a different legal collection and identify whether our findings can be confirmed in a different corpus. Finally, after fully validating our approach, we're planning to release it as an open source website where people can explore and visualize our findings in an intuitive way. We believe that such publicly available resources could, on the one hand, make it easier for legal researchers to get a bigger picture of all fields of law, journals, and scholars tackling topics relating to AI, and on the other hand, enable researchers from other disciplines, such as computer science, to have a bird's eye view on the vast body of legal literature, which might have a direct impact on their research. That was all on our side. If you'd like to find out more about the Mr. Clone Tech Lab, you can follow the link provided on the slide. Thank you for your attention.
Thanks a lot, Constanta. This was very interesting work. Are there any questions from the audience? If you have any questions, feel free to unmute yourselves and ask the question. Otherwise, I have a few. Oh yes, Nikos, go.
Hi, Constanta. Thanks for the interesting talk. My question is about how you train the LDA models. Did you actually train different LDA models to actually train different LDA models? I mean, there are actually topic models that incorporate the temporal aspect as well. But I mean, the simplest way to start is actually train different topic models over different periods of time and see how the topics change by keeping your vocabulary fixed across the different time periods. So you could compute topic similarity and so on to see how that changes, how that evolves over time.
Yeah, thank you for your suggestion, Nikos. That is indeed something we would like to do in the next stage of our study, and what was presented here is still very exploratory.
Thanks.
There's one more question here in the chat by Niels. Niels, would you like to ask it?
Hello. Yes, sure. So my question is there a way to differentiate which publications came from academic authors versus some that came from a company or even a think tank? And then also, is there a way to separate it depending on whether the authors were engineers or lawyers or social scientists? Broadly, there's more fine-grained details, obviously.
Thank you for your question, Niels. As one of the co-authors has also answered in the chat, industrial publications are very rare in this body of literature, and we do not have data about author affiliations unfortunately. So for the purpose of working with this corpus, I don't think that would be possible, but that might indeed be interesting.
I'm afraid that we need to move on. Thank you very much, Constanta. I see that there are at least a few more questions here in the Zoom chat, and I also have a few questions. You can write your questions here in the Zoom chat, and the authors can answer whenever they can. You can also post your questions in the VFAIR chat, which will be active throughout the KDD conference, right? Whereas the Zoom chat will disappear when the workshop finishes. So again, if you have more questions, please write them either in the Zoom chat or even better in the VFAIR's chat, so that the authors will be able to answer later. So we need to move on to the second presentation. The presenter is Corinna Coupette, if I'm pronouncing the name correctly.
Yes.
And the title of the paper is Complex Societies and the Growth of the Law. Corinna, can you try sharing your screen? Yeah, it's great.
I'm on my way.
All right.
Okay, can everyone see? Good.
Yes, thank you. Go.
So, well, hello everyone. My name is Corinna Coupette. I'm from the Max Planck Institute of Informatics, and this is joint work with Daniel Martin Katz from Illinois Tech, Janis Beckedorf from University of Heidelberg, and Dirk Hartung from Boston Law School. So our paper is entitled Complex Societies and the Growth of the Law. In the next 12 minutes, I'll tell you more or less what's on this agenda, and since you're going to see this again and again, let's just get started right away with the introduction. So our research interest mainly was to understand how law changes over time, which is of course a very general research interest, and it's not concrete enough to actually make a paper out of it. So our paper research question is, how has federal legislation changed in the US and Germany over the past 25 years? And our research approach, just to make sure that we're all on the same page, is that we need data-driven theory building in legal theory as well. So our theoretical foundation for that is law as a complex adaptive system. This is a fairly popular notion amongst network science scholars. And our empirical methods to investigate law as a complex adaptive system are text analytics, network science, which is what we focus on here, machine learning, and other typical data science methods. So that being said, let's look at what our data is. So the data sets that we lay as the basis of our work are taken from the legislature of the states that we investigate, and we look at statutes in the United States and Germany on the federal level, where the statutes in the US we obtain from the US House of Representatives website that has a very nice XML download available. And in Germany it's a little bit more complicated, and we obtained the data from a friendly collaboration with jurists. Our data period of observation is 1994 to 2018 inclusive, so we get a total of 25 years. And just to show you a little bit the intuition of what our data model looks like, and on the left here you can see a typical page of a German law book. Don't focus too much on the text, and this is what it looks like. It might look familiar in your jurisdiction. And what we look at is here, this is the BGB, which is the German Civil Code, and we conceptualized all of this as a graph where we take the top level name of the law as the top node, and then basically when we parse a legal text, we kind of go down. Now here we have book 3, which is about our property stuff, and you kind of go down parsing this legal text into this graph tree-like representation. And on the left, you can kind of see how that would actually work if you visually did it. Of course, the computer is much better at that. And this is kind of how it unfolds. So you can see that we have different layers of the legal text. And then also we have cross-references that kind of make this tree into a non-so-much tree anymore. So the different colors here in this illustration show you the main elements of our data model, which are basic characteristics of almost all statutory legal text. So the first here is hierarchy, which basically means you go top down in ordering your legal material. The second characteristic is referencing, so cross-references amongst legal norms to incorporate content from one in another norm. And the third content here in black is the sequence, where in each legal text, both in the United States and in Germany, you find one layer of the elements of the legal text that is uniquely sequentially labeled. And this is the section level, which in German we call paragraphs, but it's really, in English, it's section. So what do we do with that? Our data model consists of a couple of graphs, the simplest one being the hierarchy graph that just includes the inclusion relations, so one element of a legal structure containing another element. Then we have the reference graph, where you add the cross-reference relations into the already existing hierarchy graph. You can make all of this into a sequence graph to kind of model how legal scholars would navigate the legal text. And you'd basically flatten out the uniquely sequentially labeled items and weight the edges to account for their distance in the legal hierarchy. And then you just put the cross-references in. And we also frequently work with quotient graphs based on equivalence classes with multiple attributes. Here you find an example of chapters for these two dummy graphs. Basically, you just aggregate all nodes that have a certain attribute into one, and you reroute the edges accordingly. Having said this about our data model, what do we actually get if we apply it to our corpora? Well, this has some summary statistics. So for tokens, you can see that the US is roughly 3 times as big as the German corpus. It has a lot more structural elements, but on the contrary, we actually see a lot more references in the German corpus. And this is also mirrored in our results. I'm just going to give you a brief flavor of it. For the full version, you can look at the paper. So the first thing that we identify in both jurisdictions is substantial growth. So here's the figure for the US data set over time, so relative to the 1994 baseline. And you see that the tokens and cross-reference roughly grow at the same rate, but we have a much faster growth in the number of hierarchical elements that are added to these texts to group the additional content. And it looks fairly different in Germany, where actually the cross-references go a lot faster and the structures go a lot slower. So this might be a hint at different legislative techniques. And the question that we then ask after finding this kind of uniform growth, although with different emphasis, is where does this actually come from? And our answer to this, after a lot of engineering and methods that I'll go into in a minute, is that we basically uniformly find that this growth is driven by an expansion of the welfare state that's backed by an expansion of the text state. And these are the two blue-colored lines that you can see in this plot, where basically we plot the growth of the clusters that we identify as legal families over time. Now, of course, the question is, where do we get these magic figures from? And that's what I'm going to talk about for the rest of my talk. In our data pipeline, the description that's following now is basically focusing on the clustering, so the grouping of legal norms into what we intuitively refer to as topics. And what we start with is a basic quotient graph, which we call the chapter quotient graph. So here you find the chapter quotient graph for the United States. And it's colored by what you can think of for now as like similar topics. The nodes in this chapter quotient graph are the chapters of the US Code in 2018, where the size is kind of scaled by the text length. So you can see Title 42 has a couple of big chapters, which might be intuitively what you'd also expect. And the edges are the cross-references from one chapter to another, where the opacity kind of indicates the count of the cross-references. So you can already see a little bit that it's fairly like imbalanced, and there's also a lot of small stuff going on. So our question is, can we get a more expressive grouping? And the answer is yes. We use clustering with the InfoMap algorithm that's been applied in law for quite some time. The basic idea, this is now just a figure taken from the original paper, is that you perform a random walk on your graph, and you try to minimize the description length, so it's a nice information theoretic foundation, which is also mirrored by the way that intuitively lawyers navigate the legal text. So using this InfoMap method, we get what we call cluster quotient graphs. And if you just look at the overall visual appearance, now they look a lot more balanced already. Again, the colors are kind of topical similarity. But the problem now is that we actually get these quotient graphs for each year. So we have 25 of them for each jurisdiction, but how do we connect them over time? And for that, we come up with what we call a family graph. And this is one slice of the family graph here, where you basically lay out the clusters as horizontal bars, where the width of the bar indicates how many tokens each cluster has. And you do that for each year, basically. And then through a text-based alignment method that's a little more complicated under the hood, you can actually draw splines between the years that kind of indicate which tokens are moving from which cluster to which other cluster. And then you do that for all the years, and you get this nice water flow-like figure that printers also don't like to really print, which basically gives you what we call legal families that kind of correspond to legal topics. So you can look at this at multiple possible resolutions, and here we remove the edges that are small relative to the clusters that are sources of the destination. So if there's only microscopic token movement, we don't plot it. And the cluster families that we get are actually the connected components of this graph, and this is then what we take as our size measurements to obtain these drivers of the growth, where basically we identify what the topic is based on the headings of the laws that are inside. You can also do something like TF by DF. It's pretty similar, but we also use expert knowledge to kind of label the topics after we've looked at them. So with that, let me just give you a brief outlook of what else one might do. So this is kind of the research landscape that we have for looking at law as a complex adaptive system. The yellow stuff is where already work has taken place. Again, we make a contribution to the legislative system on the federal level. And what we like to do going forward is actually our view of legal data science, which is that we want to create more of these data sets that are feature-rich, well-documented, and open source. We want to analyze them using network science, text analytics, and data mining, and we want to share them with scholars, policymakers, and practitioners to improve our understanding of law as a complex adaptive system. And with that, I am ready to take your questions.
Thank you very much, Corinna. Thanks so for the presentation. So I see Niels has a question here in the chat already. Niels, would you like to ask?
Hello, yes. So I very much liked the graphs that you showed. That's something I also had to think about in my work. So especially, there's two distinct graphs. One is the structure of the law. So how does one book divide up into subsections, and each subsection divides up into more things. And the other one was how each paragraph can refer to any other paragraph. So there are cross-references within the corpus. And I was wondering if there's anything you could say about the cross-reference graphs. So yes, exactly. So the ones on the right on this slide. So for example, do you know whether they have cycles, how many? And I don't know if you have had any analysis of these.
Well, so this wasn't the focus of our analysis here. What you can clearly say is that, I mean, there are some norms that attract a lot of cross-references, and there's also some norms that have a ton of outgoing references. So these are basic things that you can just analyze by looking at the out and in degree or so. And we have like an out degree of a text norm that's gigantic, that's basically just a collector norm. We haven't analyzed anything like, are they circular, or what is the longest cross-reference path that you could go through? These are interesting follow-up questions that we could directly ask to our data, basically. So the graphs are there and they can be easily investigated, but we don't have out-of-the-box results on that currently.
Okay, thanks. Actually, I have a follow-up question, if that's okay.
Sure, go on.
So, are there implicit cross-references in German law? So, for example, can a word refer to another subsection without actually mentioning the subsection? So, for example, in US law, a word like taxable income is going to refer to a section without explicitly naming the section.
Yes, there is, and there's also been like some work done on the different types of references. I think like something that was published at the RICS conference, not by us, but by other people. So here, I mean, this is perhaps something that we should make clear. We just look at explicit cross-references. Because, so why do we do that? I mean, first, it's just a technical thing. It's much easier to identify them. And the second thing is actually where we can be fairly clear. I mean, the definition of what a cross-reference is, that it's an explicit reference, is pretty clear, whereas what an implicit reference actually refers to requires much more involved disambiguation that would require much more actual NLP going on. So right now we're exploring kind of what are the boundaries. We're trying to push the boundaries of our understanding, just using the structure that's blatantly there, because that nobody has done yet so far. And incorporating implicit references and actually disambiguating them would also be something that going forward one should do, but maybe after we have a good understanding of what we can do with the stuff that's there and objectively there for everyone.
Thanks.
Right. Let's thank Corinna again. Thank you very much for the presentation. We need to move on. So Rajaa, would you like to share your screen? That's great.
Can you see my?
Yes, perfectly. So you have 12 minutes for your presentation plus 3 minutes for questions. And before you start, can I remind people that if you have any more questions about the previous papers, you can still write them into the Zoom chat or in the VFairs chat. Thanks. So Rajaa, please go on.
So hello everyone. My name is Rajaa, and I'm a data scientist at HEC Paris. I'm happy to give you this presentation about our paper which analyzes decisions of the French Court of Appeal. And this paper is a joint work with between researchers from Polytechnique and HEC Paris. So I will be talking about the data preparation step, how we represented lawyers and cases with networks to generate a ranking for lawyers and an estimation of cases difficulty. Our work is motivated by an observation that there is an asymmetry of information in the market of legal services. One of the factors contributing to the asymmetry of information is that the legal system is too complex for lay person who find difficulties, for example, selecting the right lawyer. And we believe that mining information from large data sets and representing it in a user-friendly interface is one of the solutions to address the access to justice gap, because it contributes to improving decision making by providing both consumers and policy makers with insights. So the objectives of our study are to first produce a ranking of lawyers from their experience, which is recorded in judgment, and second, estimate the difficulty of a case to provide more credible information about the performance of the lawyer in the court. So during the data preparation phase, we first scraped 40,000 decisions from Legifrance, a French legal publisher providing access to law and codes and legal decisions. And we limited our analysis to around 17,000 cases from the Court of the Appeal. Another important step is the analysis of the structure of judgments, since it varies across jurisdictions and dockets. All the decisions have similar macro structure. As you can see in this figure, we have most of the time 5 segments. And in our study, we need to segment the decisions into this segment. So we use a key phrase approach, where we use these key phrases that precedes each segment in order to do the segmentation. But since the decisions varies in wording and phrasing, we needed to discover in an automatic way these key phrases from our data set. So we use a graph to represent the structure of decisions by where here you can see there is this graph representing decisions from the city of Douai, and here a graph representing decisions from the city of Agen. And the nodes are sentences from judgments, and the size of the node is the frequency of the sentence in all judgments, for example, here from the city of the way. So large nodes help us discovering the common parts between all documents and to build the list of key phrases to segment decisions. Then once we have the key phrases and we do the segmentation, we obtain first these segments. Here we'll have the introduction. This segment contains information about the appellant, and the same here for the appellee. And these segments help us in targeting the sentences that contains the names of lawyers. So first we tokenize each segment into sentences. We filter sentences using key phrases like here, like maître, that precedes the name of the lawyers, in order to keep only the sentence which contain the name. And then we use a method which combines named entity recognition model and key phrase to extract the name. And the named entity recognition model, we used one that was pre-trained and is available in the Polyglot package. Then the last step is in the processing is to know who won the decision. So we refer to the conclusion segment, which contains the decisions of the judge. And we classify the decision into a win or a loss using the keywords that the decision contains. So if the decision contains words like confirme, rejette, then the decision is in favor of the appellee, and the appellee's lawyer is the winner. If the decision contains words like infirme, rectifié, then it is the appellant who wins. So once we finish the processing of decisions, we create networks to represent lawyers. Here, the first network is what we call a collaboration network, where nodes are lawyers, and the edges connects lawyers who have collaborated on the same appeal case. And we weight the edges by wins minus losses, and we color the edges to indicate whether the collaborations have more wins or more losses in order to visualize successful collaborations. The second network is the opposing network, where edges connect lawyers who have been opposed. The edge goes from the losing lawyer to the winning lawyer, and its weight is proportional to the difference of wins between the two lawyers. And the node size is proportional to the number of cases of the lawyer. And we here also use the color to indicate lawyers who have more wins or more losses. We leverage the opposing network to compute a ranking for lawyers and compare it with basic rankings. The first ranking is based on the number of cases mentioning the lawyer, and the second ranking is based on the win-loss rate. The main weakness of the first ranking is it doesn't indicate the performance of the lawyer, unlike the win-loss rate. And the win-loss rate ranks first lawyers who has more wins than losses. However, it doesn't take into account the experience of the opposing lawyers. So this is where a network representation of the lawyer is useful, because it encodes the relationship between lawyers and therefore allow us to evaluate lawyers with measures that reflect the importance of the lawyer in the whole network of lawyers. So we use the weighted PageRank algorithm to produce the third ranking, where top lawyers are lawyers who won the most against experienced lawyers, and also who won as an appellant lawyer, since the weights of the edges give more importance to wins as an appellant lawyer than wins as an appellee lawyer. Then we build graphs to represent cases in order to compute the difficulty of cases. So the network is composed of cases which are linked when the cite at least k common legal articles, because cases about the same legal issues tend to cite the same law articles. And as you can notice here, by increasing the number of common articles, the community structure of the graph becomes more visible, such that we have groups of cases with dense internal connections and sparse external connections. And we tested different values of K on our data set. Here we have the value K equal 2 and here K equal 4. And as you can see again, the community structure is more visible for a higher K. And then we investigated some communities from the graph and found that indeed these communities are about the same legal issue. So community A is about Airbnb long-term renting, and community B is about employees of SNCF, the French national railway company, claiming their holidays. And another property that we noticed in the communities is that the win-loss rate is homogeneous inside the communities. So communities circled in red have high losing rate, and communities circled in green have high winning rate, which means that some type of cases are harder to win than others. To conclude, in our study, we used network methods to represent lawyers and cases. The opposing networks of lawyers allow us to compute a ranking of lawyers which takes into account the experience of the opposing lawyers. And the network of cases serves us to explore communities of cases about the same legal issue, and also to compute the difficulty of these cases by using the win-loss rate as a proxy for their difficulty. So thank you for your attention, and I would be happy to answer your questions.
Many thanks for the presentation. I see several questions here. I think the first one is from, at least one of them is from Alexandra. Alexandra, would you like to ask your question?
Should I read it from the box?
It's okay, I can read it. It says, can a decision be a partial win or loss? And if so, how do you disambiguate if both sets of keywords appear in it?
Yeah, so true it is, we might have both keywords in the decisions. So we decide it is a win if we have the majority of positive keywords.
Right. Another question by Frank says, how do you tokenize the name of lawyers when there are several lawyers representing one party?
Yeah, first we can have, we have two scenarios. We have several names of lawyers in the same sentence, and here the named entity recognition model that we use is able to recognize the presence of multiple persons in the same sentence. And the second scenario that we have is we have in the same segment several lawyers but in different sentences. And since we separate the sentences before doing the named entity recognition, so we are also able to recognize the presence of other lawyers. And this is what also enables us to build the collaboration network. Because if lawyers appear in the same segment, like appellee segment or appellant segment, it means that they have collaborated on the case.
Thanks. There's another question by Tom. Tom, would you like to ask it? Sorry, we've answered that. Sorry, that was previous one. So I'm a bit lost here. Yeah, so it's another question by Gina. Gina, would you like to ask a question?
Sure. I thought it was interesting that you had these two sections, one where you were talking about analyzing lawyers by their win-loss rate, and another where you found that some types of cases were intrinsically harder to win. I was wondering if you thought about integrating those two. A lawyer who wins hard to win cases would seem to be one who should derive additional benefit from that, even if overall their rate might be lower.
So if I understand well, your question is whether to integrate the win-loss rate with the difficulty?
Something like that, yeah.
Yeah, actually here we use the win-loss rate as a proxy to the difficulty. So here what we mean by difficult is cases that have a low winning rate. And so our hypothesis in the beginning was that there is some legal issues are harder by nature, like to win than others. And hard here, they have like a low likelihood to be won.
Right. I guess the question I was curious about was whether you could incorporate that into your lawyer ranking.
Yes, okay, I misheard. It's in our future work. As we mentioned in the beginning, is that the win and loss isn't enough information to indicate the performance of the lawyer, because he won the case, but maybe the case was easy. So we would like to integrate the difficulty in the ranking.
Great, thank you.
Right, thanks a lot. I'm afraid we have to move on to the next paper. So thanks again for your presentation, Rajaa. There's at least one more question here that I got confused and I didn't ask. So apologies if I've skipped any other questions, but the authors can always reply in the chat. So let's move on to the final paper of this session. The presenter is Lepp. And the title is Pardon the Interruption, an Analysis of Gender and Turn-Taking in U.S. Supreme Court Oral Arguments. So, would you like to share your screen? Thanks. Great, so can go on.
Hi, everyone. Can you hear me all right?
Yes.
Great.
Perfect.
I hope you're all safe and well. I'll be presenting my graduate research on gender and turn-taking in U.S. Supreme Court oral arguments with my advisor, Gina-Anne. Our work is less a text analysis and more an explanation of how the law is produced through speech. People have long argued that women are interrupted more than men in professional settings. Legal researchers at Northwestern University and the University of Michigan have found that U.S. Supreme Court arguments show evidence of interruptions correlating with gender, which are consistent over time and are not linked to political polarization or justice personalities. In this talk, we'll present a corpus of annotated spoken exchanges from Supreme Court oral arguments. The corpus of turn changes and annotations is available for public use. We examine the distribution of labels and we do find gender bias. And then to demonstrate the utility of the corpus, we extract speech features from the turn changes and show that classifiers can automatically predict the human labels of turns with relative success. We selected 4 cases from the 2018, 2019, and 2019, 2020 turns in which each has at least one female attorney speak. This actually limits options considerably. For example, in 2018, only 15% of the people who argued before the court were women. We retrieve all recordings, transcripts, and timestamps from the OIA project. We define a turn change as an event in which the transcript shows one speaker stop speaking and another speaker start speaking. So for in this example, Hannah S. Jurse starts speaking, and then Chief Justice John Roberts follows after her. Using the start and end timestamp of each speaker's turn, we segment each argument into 6-second audio clips around turn changes, 2 seconds before the turn change and 4 seconds after, with exceptions relating to the length of each turn. This short size clip actually helps avoid annotator bias against case content and ensures that the annotators, who are busy professionals, don't lose interest in the task. We manually check each segment and remove those in which speakers are inaudible, list those which are listed as separate turns but are actually just the same person speaking, and turns that are scripted, such as Mr. Chief Justice and may it please the court. We do trim some recordings and extend them if it makes the turn more clear. This is all documented within the public corpus. We update speaker names if there's incorrect ordering or names are incorrect. And again, all of this is described in the public corpus. Labeling the turns, though, it requires a standardization of terms. Interruptions have, in various relevant studies, been used to describe acoustic overlap, syntactic cutoff, acts of dominance, acts which wrest control of the discourse from a speaker, topic change attempts, ways to bolster the interruptee's positive face, back channels such as or right, and then also not back channels, markers of certain dialects of English, and then, of course, strategies for questioning people in court. So we decided to label the turn changes on a spectrum. On one side of the spectrum, we have cooperative turn changes, in which the first speaker intends to cede the turn to the next speaker or are continuing their turn across back-channel speech. And then competitive turns, in which the speaker does not intend to cede the turn, but the second speaker does start talking regardless. The rules of conversational speech within courtroom setting are not the same as those in informal conversational speech. As such, all of our annotators are required to be US-based to identify as attorneys, judges, legal scholars, or law students in their second year or above. We designed a brief, easy-to-complete, anonymous online survey for legal professionals. The survey is built on the JavaScript library JS-Psych. We instructed participants to categorize the clips on a spectrum of cooperative to competitive, as seen in this picture. And then before beginning annotation, the participants are given descriptions of each category and some trial exercises for normalization, and example audio clips that can be classified into each category. Again, this is the interface. There's a prompt and then an audio element that the user can control and a slider showing a spectrum with these sort of Likert-style category labels. The annotators are given up to 26 segments to listen to. We selected this number to keep the exercise under 5 minutes for each annotator. Though if they for completion, all the results are still saved.
I'm afraid that's beyond my abilities for now.
Oh no, Siri. We had 77 participants take the survey, leading to 711 unique annotated segments, each annotated twice. There are 11 male speakers, including Justice Thomas, who does not speak, 9 female speakers. Of the annotated turn changes, most turns are justice to attorney or attorney to justice. Justices rarely address other justices, and attorneys never address each other. The turn changes by gender are relatively widespread. For example, the largest category is male to male, and the smallest is female to female. I should note that we did collect our gender information from public profiles of speakers. If the corpus is expanded, it's important that the demographic information, if it's gender or race or whatever, needs to be aligned with how the speakers do self-identify. We also document the demographics of our annotators and compare them to the American Bar Association registered lawyers and the general U.S. population. This is because the way that listeners do perceive speech, it differs due to many factors. So we wanted to ensure that linguistic diversity of listeners was relatively representative of the diversity of the United States. This is all included in the corpus as well as other demographic categories. The distribution of labels reflects the layout of the web interface. So we see the highest peaks are at either end of the spectrum and then directly in the middle. This shows that annotators are just moving the slider all the way to one end if something sounds clearly competitive or cooperative. We also see middling peaks around where the survey interface has labels of slightly competitive or slightly cooperative. So people are using those Likert guidelines, even though they can put the slider anywhere on the spectrum. Inter-annotator agreement on the raw labels, as well as labels categorized into 5 equally spaced bins, are shown here. And they do indicate moderate agreement. The areas we see higher disagreement is when the speakers are speaking at the same time, but are saying things that kind of come across as polite, such as, if I may, Your Honor, or sorry, Your Honor. To investigate the relationship between gender and competitive turn-taking, we explore the distribution of turn change scores with respect to the gender of the first speaker in a turn. And then for comparison, we also show the distribution of these turn changes with respect to whether the speaker is a justice or an attorney. The mean score of an exchange when a woman is the first speaker in an exchange is more competitive. So we've got 45.0 with a standard deviation of 28.1, and that is in comparison to when a man is the first speaker, that's 49.7. Alternatively, the mean label for a turn in which a woman is the second speaker is slightly more cooperative than when a man is speaking to someone. More extreme is the difference between roles. The mean label for an attorney first speaker is 36.3, while a justice first speaker has a much more cooperative mean of 59.0. This is predictable considering the power differential in the culture of deference. Attorneys would obviously avoid speaking competitively to a justice, while justices would be much more likely to speak to an attorney competitively. So this chart shows the distribution of labels for each speaker in the corpus who is being spoken to. So this is when they speak first and then someone else in the clip speaks second. The distribution eliminates the severity with which role aligns to turn change type. So if you can see, the 8 people most cooperatively spoken to are all justices. On the flip side of things, this is where the people are the second speaker. The speakers who have the lowest means are spoken to most competitively are all attorneys. So to explore automatic classification, we focus on extracting features which can be used to provide actionable feedback to speakers, potentially maybe in future trainings on anti-bias. There are several acoustic and prosodic measurements which have been shown in previous linguistic studies to be indicators of competitive speech. These include pitch contours, such as the one shown in the spectrogram. You can see the turn changes, that thin red bar in the middle. That's the high-low pattern after a turn. Amplitude, which tends to correlate with loudness in speech. Silence gaps between the turns or overlap between the turns. Many of these measurements, there are many measurements for each of these elements, and these exist in pre-built feature sets. So we use the EG Maps collection of 88 psychologically informed features. It's been demonstrated to be successful in emotion recognition studies, as well as the speech prosody set, because it includes patterns with pitch and amplitude, which again have been shown by previous studies to predict interruptions. In each feature set, we do also include gender and role information for the first and second speakers. We use an 80-20 split with gender and role distribution preserved. This is not speaker independent, largely because from case to case, there's a lot of the same speakers. We group the mean label for each segment. So again, there's 2 annotations per segment. So we take the mean and then we group that into tertile-based bins. So the most cooperative tertile, neutral, and most competitive. We ran random forest and SVM classifiers using Scikit Learning Laboratory Toolkit. We scaled features by standard deviation and centered around a mean, and what we'll be reporting is the F1 score. So we compare our results to a baseline of a binary value of whether the transcription of the first speaker's speech ends in a dash or not. So a dash, for example, could indicate syntactic incompletion of a sentence. And we do demonstrate that our model solidly outperforms this particular baseline as well as a guess of the majority class. The prosody feature set does perform the best, likely because of the emphasis on pitch and amplitude features. I should note that these models do not use gender normalized features, which is unusual for models which take advantage of prosody, because prosody often correlates with gender. But we did find that actually decreased the accuracy So future studies might explore what's going on here with including non-normalized features, and also future studies could look at using text features in combination with these prosodic and acoustic features. So in conclusion, we presented a corpus of turn changes labeled as competitive or cooperative. We do show that female speakers and attorneys are spoken to more competitively than our male speakers and justices. We demonstrate that classifiers trained only on phonetic and acoustic features can achieve relatively high predictive accuracy. And again, our corpus of turn changes and all the related information is available publicly. Please make use of it. Very grateful for the many scholars who supported this cross-disciplinary studies, people at ETS where I work, as well as at the University of Washington, and the reviewers and participants at Widening NLP at ACL last year. We thank the legal professionals who annotated the data and helped test the annotation survey. And finally, we do express our appreciation for the public servants and activists who spend their daily lives fighting for equality and fairness in the U.S. judicial system. And here are our references. Thanks. Do any of you have any questions?
Thank you very much. I don't see any questions here in the chat, but if anybody...
Sorry, I actually have one. I was typing it, but I might as well say it. I'm sorry if I missed this maybe, but you said that attorneys and female lawyers, attorneys and females are more challenged than justices and males, but I'm guessing that these things are correlated maybe. So I actually don't know what the ratio of male to female is in justices and male to female in attorneys in Supreme Court cases. But are these things correlated in some sense?
Sure. So there's definitely the distribution. There's many more male speakers, and then there's more attorneys than there are justices. We take this into account in our statistical measurements, so that's controlled for the number of females and males who are arguing. Let me pull up this slide. Oh no. Oh, I guess I can't share it anymore. But yes, the distribution is all listed on the GitHub page. I'll share that in the chat, and please feel free to take a look at those distributional statistics.
Okay. Any other questions? Again, you can also write your questions in the chat. I'll post a couple of questions there, but we should probably thank Halle again for your very interesting talk. Thanks a lot, because we need to move on to the next session number 2, which is about NLP applications.